Hi Jane, are you good to go?
I see two, yeah, okay.
Yeah, cool. I'll just hit broadcast.
Okay, good morning everyone, and welcome to this webinar on being ready for the end of the Brexit transition period, which is only a couple of days away, as I think we all know. My name is Jane Milroy and I'm going to be presenting the webinar today, as well as responding to any questions that you may have. In a moment, I'll go through the different topic areas that we're going to be covering today. But before that, I'd just like to say, well, the webinar is scheduled to run until around 1 p.m, but I think it's likely that we will end quite a bit earlier than that. Some of the content has changed, obviously, in the light of recent events. I should also say that around 11 o'clock, we'll probably stop for a 5-minute comfort break, so just so that you're aware of that. As I'm going through the different topic areas, feel free to put your questions. If you can use the Q&A function, which is on the button in the middle of the control panel. I'll try to answer as many of these questions as I can before the end of the webinar, but for any that I'm not able to answer live, I will be providing answers and signposting to more detailed information on the webinar handout that everybody will receive after the session. I should also let you know that today's webinar is being recorded, so the chat function has been disabled. So as I said, any questions should be put through the Q&A function on the button in the middle of the control panel. There are a lot of topics to go through, and some of them are more obvious than others, and I will be going into as much detail as I can, but for some of them you may need to consult further resources to get the full picture in relation to your own particular situation. I'll be signposting you to useful resources and additional information, and this information will also be available on the handout that you will be sent after the webinar, as I've mentioned. So I think as we're all aware, the UK left the EU on the 31st of January 2020, and that's when we entered this current transition period, during which both we in the UK and also our EU counterparts have continued to act pretty much as if the UK were still a member state. So the transition period will end at 11 p.m, that's UK time, on the 31st of December 2020, and this is written into law. And then, as I'm sure you are all aware, on Christmas Eve, a trade deal was announced between the UK and the EU, and I will be referring to elements from this as we go through the different topics. But it is really important to understand, and I guess the fact that you're here means that you do understand this, that even with the deal, there will still be significant changes to navigate. So this webinar aims to cover the key areas that you need to be aware of and potentially address. And as I said, in addition to the content that I'll be delivering today, there will be signposting to a number of useful resources that you'll be able to use to get more detailed guidance on how to follow some of the specific processes relevant to your business that I'm going to be covering during the webinar. There are also some sector-specific issues that you may need to be aware of for your business. I will be highlighting some of these later, but because this webinar is aimed at businesses from all sectors, I won't be able to go into full detail on these topics. Just now trying to move my slide. It always seems to be stiff at the start. Sorry about this. There we are. Okay, so to get us started, I thought it would be worth summarising some of the changes that we're going to see when the transition period ends, and therefore the key areas that this webinar is going to cover. One of the most known about but not necessarily fully understood areas is around the movement of goods both into and out of the UK. I'm going to start by explaining a bit about free trade agreements with other non-EU countries, and that's for the benefit of any businesses on the webinar who are trading with or exploring opportunities in any of these countries, and I'll explain why that's relevant. I'll be looking at rules of origin, which underpin all free trade agreements, including the one that's just been agreed between the UK and the EU. It's really important that you understand these if you are importing or exporting goods, because they determine whether the goods you're trading qualify for the tariff-free trade that has been agreed. Leaving the EU is predicted to lead to an increase in customs declarations from around 55 million per annum to 270 million per annum. And this is not affected by the deal that has been agreed because the UK is leaving the customs union, which is the instrument that meant declarations were not previously required, whereas now they will be. So we'll go through the implications of this both for importers and for exporters, and the steps that need to be taken to maintain trade and avoid goods running into problems at the borders. There are also a number of financial considerations, particularly around VAT, that need to be considered, and again, that's for both importers and exporters. So understanding your options here and preparing accordingly can have a significant impact on cash flow and your overall costs of doing business. So it's important to understand these properly in the context of your own business. For companies that are importing and exporting goods as part of a more complex supply chain, there are also some schemes to be aware of that may help cut down paperwork and reduce costs. In looking at all of this, we need to bear in mind the unique position of Northern Ireland in the future trading agreement, so I will also be looking at this. Trade and services is a large part of the economy, and at this stage there are still some unanswered questions and grey areas, but I will go through some of the key things for services companies to be looking at. For companies currently selling online who've been benefiting from the Ecommerce directive, it's important to understand the necessary steps to take to remain on the right side of the law in any European Economic Area countries that you operate in. Intellectual property is a complex area where Brexit has a number of implications, and these need to be understood and acted on if you wish to continue benefiting from relevant IP protections. CE marking is one of a number of schemes where the UK government is launching a UK version to be used from the 1st of January 2021, and we'll also cover this. Data protection is another complex area, and there will be considerations for companies, particularly those who receive data from the EU to the UK to ensure compliance, because this has not been finalised yet as part of the trade deal. It's not finalised. Then on the legal side, an important area to consider is reviewing any contracts that you have, and I'll be going over the key things that you need to look out for here. Also, if you employ any EU nationals, we'll be looking at some of the key things to be aware of, as well as some of the implications for travel to the EU post-Brexit. So starting off looking at, let's look at free trade agreements and what you need to know about these if you're trading with or planning to trade with any of the affected countries beyond Europe. So this is not about trading with the EU, but it is still affected by the UK leaving the EU. The EU currently has 44 preferential trade agreements in place covering 77 countries in total. Some of these agreements are with other trading blocs, such as the Eastern and Southern Africa or the ESA trade bloc. Others are with individual countries. At this point in time, excuse me, the UK has successfully negotiated 27 agreements covering 56 countries worldwide. Recently concluded are some of the more significant of these, including Japan, Singapore, Canada, and Mexico. The latter two, Canada and Mexico, are not expected to be fully in force on the 1st of January 2021, but they are expected to be in force early in 2021. So there's a link on this slide that takes you to the gov.uk website, which is continually updated whenever a new deal is agreed or comes into force. So these agreements matter because you may find that you're buying from or selling to countries where there's currently an EU agreement in place that will no longer apply after the 31st of December 2020. And if this is the case, then additional tariffs may need to be accounted for. So if you're exporting, you should check if any of your if any of your customers are in such countries, and if so, you should check the tariff that will apply under WTO rules. So you can find this information on the WTO website, which I've got a link to on this slide, and you'll get that with the webinar handout. For importers, importers should check if they're buying from any of these countries. As for you, the EU's common external tariff will be replaced by the UK global tariff. You may also wish to consider applying for a duty deferment account to help with cash flow and reduce administration. This allows you to make a single monthly payment for import duty, import VAT and excise duty if applicable. And I've included a link to the relevant section on the gov.uk website with further details on how to apply for this in a slide a little bit later on. If you are already importing or exporting from a non-EU country, you should already know what the relevant commodity or tariff code for your product is. But in case you don't, and to help those who are not currently trading out with the EU, I'm now going to play a short video which explains commodity codes and how to identify the correct one for your goods. So this just takes us to an external site.
Commodity codes, sometimes referred to as tariff codes, are numbers used by customs authorities, such as HMRC, across the world to classify imports and exports. Each type of goods has its own code used internationally. Import codes have 10 digits, and export codes have 8. HMRC uses these codes to work out how much customs duty or VAT you owe on goods you move into or out of the UK. You need a commodity code to complete import or export declarations and other paperwork for your goods. As a business owner, it's your legal responsibility to use the correct code. If you use the wrong code, your goods could be delayed or seized. You might pay the wrong amount of duty or VAT, and if you pay too little, you may have to pay extra charges. Once you have the correct code, you can check if you need to pay duty or VAT, and how much. You can also see if there are any duty reliefs or restrictions on your goods, or if you need a license to move them. Use the Trade Tariff tool on gov.uk to find the correct commodity code for your goods. You can search for your goods by name, use, or material. Or try a more general term. So if you're importing earrings, search for jewellery. You can also use the A to Z index to find the right sections and chapters for common goods, where you'll find the commodity code. Some goods are harder to classify than others. If you need more help, there's guidance on gov.uk.
Okay, so just moving on to if you're importing from any of these countries. So the UK global tariff is a new regime that will be defaulted to when no trade deal has been agreed between the UK and a particular country. So the UK general global tariff will apply to all goods imported to the UK unless an exemption applies. Exemptions apply when the goods come from countries where there is a free trade agreement in place, as you'd no doubt expect, or if they come from countries that are part of what is known as the generalised scheme of preferences. So these are imports from an agreed list of developing countries. We currently operate under an EU version of this, which will be replaced by a UK-specific scheme from the 1st of January 2021. In general terms, the UK government has stated its intention that overall tariffs will be reduced through a combination of simplification of rates, a reduction of rates, and a removal of rates. However, some key industry tariffs will remain in place. And specific tariffs can be checked using the gov.uk trade tariff tool, which you just saw a demonstration of in the video that I played. And then just to reiterate, this is a continually changing picture, with the UK government actively seeking to roll over all of the current EU agreements. So you should keep up to date with this in case a deal is agreed with a country that you are trading with. So the next couple of slides provide the current picture in terms of which countries have agreements and which ones where there's currently an EU agreement in place do not yet. And for the countries, so these are the ones where there isn't yet an agreement. So for these countries, as I say, the government is working to roll these over. And one of them on here, Turkey, for example, is expected to be signed imminently. That was one that couldn't actually be agreed until after a deal was agreed with the EU. So that one is expected very soon. Okay, I mentioned duty deferment a little bit earlier. This is just a slide where you can get the information if you think that that might be something that would be useful for your business. Okay, so moving on to rules of origin. So rules of origin underpin free trade deals, and requirements of these need to be met in order for your goods to benefit from tariff-free trade. So this applies to the free trade agreements that the UK has already agreed with non-EU countries, as well as the free trade agreement that was announced between the UK and the EU last week. So currently, rules of origin do not apply in the EU single market. So up until now, only British companies that were exporting outside the EU had to take them into account. And also EU trade, and thereby UK trade, with the rest of the world is currently governed by pre-agreed EU rules of origin set out within the EU's trade agreements with specific countries or regions. So in the newly agreed free trade agreement, the EU and the UK have had to agree a new set of rules covering the origin of the products traded between them. I'll warn you, this can get quite technical, and there are some product-specific agreements. So I've included links to information on this for you to consult if you think you need to for your own business and products, if you need to check up on this. There are two basic criteria that are commonly used in setting rules of origin, and they are, firstly, whether a good is what's known as wholly obtained. So this is when a good or product naturally occurs in a country. So for example, it could be where live animals are reared, it could be where plants are grown and harvested, or natural minerals are extracted in a particular country. The definition of wholly obtained also covers goods produced from scrap and waste derived from manufacturing or processing operations or from consumption. So in other words, recycled goods. And then the other criteria is whether a good has undergone what is known as a substantial transformation in a particular country. So when a good is considered to have been substantially transformed, having undergone specified manufacturing or processing. So I've put an example there as biscuits being one example. And one of the ways that this can be demonstrated is when the manufacturing process results in the product changing tariff classifications. So the commodity codes that I just showed you, where that commodity code changes completely, that is one way of demonstrating substantial transformation. Cumulation is another important term in the area of rules of origin, and this is covered in the trade deal that has been done with the EU. So this means that countries can share production and jointly comply with the rules of origin provisions. So for example, if a product is made in the UK partly with materials that originated in the EU, they can qualify as UK origin, and that works in the opposite direction as well. If, however, goods are made with significant content from out with the UK or the EU, they may not qualify. And if this is the case for you, it is advisable to check whether you will be able to meet rule of origin requirements. And determining the country of origin of a product is usually the final step in the customs clearance process after the customs classification and the value of the goods are known. So for exporters, an additional piece of paperwork that will be required to prove the origin of your goods will be a certificate of origin, which you can get from your nearest Chamber of Commerce. And then for importers, you need to make sure that any EU suppliers are aware of this requirement for goods coming into the UK. So now let's look specifically at moving goods between the UK and the EU from the 1st of January 2021. I'm going to start by talking about importing. So these are the key headings that we're going to be looking at. So the EORI number, the 3-stage implementation for importing that's been announced, changes to VAT, using a customs intermediary, simplified customs declarations process, and also Incoterms. These Incoterms actually apply to both importing and exporting. So starting off with the EORI number, this stands for Economic Operator Registration and Identification. Up until now, businesses have needed an EORI number to move goods between the UK and non-EU countries. So if you were only trading within the UK or only exporting to the EU, an EORI number was not a requirement. From the 1st of January 2021, you will need one to move goods between Great Britain, so by that's England, Scotland and Wales, and the EU. And you may also need one if you move goods to or from Northern Ireland. It's really important to make sure that you have this in place, because without one, you may have increased costs and delays. For example, if HMRC can't clear your goods because you don't have the correct paperwork, you may have to pay storage fees, for example, which add up and add up. The good news is that applying for an EORI number is very straightforward, and it can be done on the gov.uk website. I've provided a link on this slide. It can take up to a week to receive, but it's often quicker than this. Perhaps not at this particular time of year, but it's not something that you have to wait weeks and weeks and weeks for. If you do already have an EORI number, you do need to check that it starts with GB, because if it doesn't, then you should apply for a new one. So now moving on to the nuts and bolts of how importing from the EU is actually going to work, along with the key dates that you need to be aware of. So in June this year, the government announced that it would be implementing a phased approach to imports from the EU, and that's to allow businesses more time to prepare and adjust, and to try to reduce the risk of huge hold-ups at the borders, resulting in disruption to supply chains. So the key dates for this process, which is being phased over 6 months, are the 1st of January, the 1st of April, and the 1st of July. So the first phase applies from January the 1st. And from this date, traders importing standard goods, so that covers everything from clothes to electronics and a range of other, most products, to be honest, will need to prepare for basic customs requirements, such as keeping sufficient records of imported goods. And then you'll have up to 6 months to complete the customs declarations. From this date, import VAT will be due, but there are options on how you can account for this, which I'll cover in a moment. There will be checks on controlled goods like alcohol and tobacco. So these are among the goods that are defined as controlled as opposed to standard. I've also put a link on the slide so you can check a link to controlled goods, so that you can check if you're in any doubt as to whether your goods are controlled or not. There will also be physical checks at the point of destination or other approved premises on all high-risk live animals and plants. So that's not at the point of importation, that's at the point of destination. Phase 2 from April the 1st. This phase really only affects products of animal origin, for example, meat, pet food, honey, milk or egg products, and also all regulated plants and plant products. So from the 1st of April 2021, all of these will require pre-notification and also the relevant health documentation. And then phase 3 from the 3rd, from July 2021, 1st of July 2021. So from this date, traders moving all types of goods, whether they are controlled or standard, will have to make declarations at the point of importation. And full safety and security declarations will be required, and for sanitary and phytosanitary commodities, so those are foodstuffs, live animals and plants, etc., there will be an increase in the number of physical checks and the taking of samples. And the change here is that checks for animals, plants and their products will now take place at GB border control posts, so no longer at the point of destination. Looking at importing and the VAT implications. So unlike before, import VAT will become payable on goods imported from EU countries. And you will need to take this into consideration when you're looking at cash flow for your business. The introduction of postponed accounting will, however, alleviate this to some extent, and perhaps fully for some businesses. So under this arrangement, UK VAT registered businesses with a UK EORI number can pay import VAT on their quarterly VAT return rather than when the goods actually arrive at the border. And you should also be aware that there are that a number of the EU VAT simplification measures that are currently in place will no longer be available. So if you're using any of these, you need to check and check the impact of this and make provisions. I've put a link in here to further information on import VAT to help. One of the decisions that you will need to make if you haven't already is whether or not to use a customs intermediary to handle your import or export paperwork for you. So customs intermediaries include freight forwarders, customs agents or brokers, and also fast parcel operators. For importing goods to the UK, you do need to use a customs intermediary that is based in the UK. And when you're choosing one, you should check that they cover the port of entry of the goods that you're bringing in. I've put a link on the slide to a list of government-approved customs intermediaries that you may want to consult if you're needing if you want to find one. And I'm also now just going to play a short video which just explains a bit more about customs intermediaries.
You need to declare any goods to HMRC that you send abroad or bring into the UK for your business. This is done using a customs declaration form. Customs declarations are complicated, so we recommend you get someone to deal with customs for you. This is known as a customs intermediary. An intermediary is simply someone who makes declarations for you. This may be done by the business that ships or moves your goods, like a freight forwarder or haulier, but it can also be a specific customs agent or broker. Some other examples are logistics companies, couriers, customs warehouses, or parcel and express operators. The customs intermediary has access to HMRC systems and the specialist software needed to make customs declarations, and can also provide advice about how best to move your goods. They will complete the paperwork for you and make sure your goods have all the approvals needed to move them across borders. This makes the process easier and often cheaper than doing it yourself. If you decide not to use an intermediary, you will need to make declarations yourself. You will need to buy specific software, make sure staff are trained and have the approvals required. From the 1st of January 2021, these rules will begin to apply to goods sent between Great Britain and the EU. You can find more information about hiring someone to deal with customs for you on gov.uk.
Okay, so when you're deciding whether or not to use a customs intermediary, you need to weigh up the pros and cons in terms of the costs, the resource that's needed, but the need to keep your business running smoothly. When it comes to the cost of using one, each customs broker will offer slightly different services, and their charges can therefore vary widely. If you're using a freight forwarder, which will also act as your customs broker, then you should be able to see the customs element of their service detailed in their itemised quote and contract, and you can then compare their costs to other organisations. You'll find that most customs brokers prefer to offer a tailored quote, as their fee will depend on the products you're importing, their value, their point of origin. For example, if your goods need licensing, then this could cause additional work for the broker, and they will add a fee for this. Bear in mind that some of these costs will still be incurred if you choose to do your own paperwork, but the kinds of things that you would expect to see in an itemised quote would be things like the customs clearance charge, and then depending on whether you're using air freight or sea freight, various associated charges. There may be government agency fees for inspections, bank transfer fees, agency fees, and then potentially also onward delivery costs if they are needed. There are some customs brokers who advertise a flat upfront fee, and I've seen this to be as low as £29. And while these offers may be worth considering, you should be wary of any small print or added extras, because these can obviously soon add up to a significantly higher fee. And as with all service agreements, you need to be very clear on what you can expect from your customs broker before you sign on the dotted line. And also, if you're shopping around, just make sure that you are comparing like with like. If you choose not to use a customs intermediary, you'll need to be sure that you have a full enough understanding of the necessary paperwork or recruit and train somebody to do this for you. You'll also need to make sure that you have the appropriate software to allow you to make your own declarations, and that you've registered for the CHIEF, which stands for the Customs Handling of Import and Export Freight System. There are grants available for recruitment, training, and also for IT related aspects of getting ready to do your own customs declarations if you haven't done them before. And I've provided a link to that information on this slide. My general advice to companies who haven't dealt with customs before is to err on the side of caution and appoint an intermediary, at least for the first few months, to enable you to keep continuity and also get a better handle on what's involved and what the costs to the business are. You can obviously review this at any time and move to doing your own declarations if you think that that's going to be better for you going forward. Various things that need to be taken into account. I mean, one factor with a company that I was advising recently was the fact that they were actually only importing one product for a supply chain that has multiple products and ingredients. So for them, it wasn't actually worth their while going through the process of manning up and putting in the resource to do their own declarations. So you do need to weigh up all these factors for your own particular business situation. So just a word about simplified customs declarations. So as I mentioned when I was explaining the phased approach that the UK government is taking to the introduction of import controls for non-controlled goods that are imported from the EU until the 30th of June 2021, where traders may automatically be entitled to use the simplified customs procedures by simply recording imports in their own commercial records at the point of entry of the goods, and then following up with a supplementary declaration within 6 months. In order to submit the supplementary declaration and to continue to use the simplified customs declaration process after the 1st of July 2021, which is possible, it's necessary to be authorised in advance. So for the first 6 months, it's not necessary to be authorised, but once you start to lodge the declarations, you do need to become authorised. And you can apply using the link that's on this slide. If you do want to use this process going forward, you should make sure that you do it in plenty of time so that you avoid any issues come next July. Incoterms, so these are very important. Incoterms basically define who between the buyer and the seller is responsible for paying for and managing the shipment, insurance, documentation, customs clearance, and other logistical activities to get purchased goods to their destination. There are 11 different terms, and some of the more well-known ones are things like ex-works, delivered duty paid, and free on board. I've put a link to the full list on the handout. One of the key things to be aware of is the need to be very clear on who will be responsible for customs clearance within your agreement. So you may need to revisit any buying contracts or arrangements that you have with your existing suppliers to establish and agree this, and then also be aware of this when you're looking at any new arrangements that you're making in the future. So this slide is basically a summary of the key steps for importing from the EU to the UK. And at the bottom, that link takes you to a nice little kind of flow diagram that's on the government website that helps. It looks at whether you're using a customs intermediary or not, and the different things that different processes that you need to follow depending on those choices. So it's quite a useful link to use. Okay, so now we're going to look at the exporting side of the picture. And for this, many of the same things need to be considered as for importing. But I'll now go through all the different steps and highlight the additional things that exporters will need to be aware of. And again, at the bottom of this slide, there's a very useful guide on the gov.uk website for exporting to the EU. So EORI number, we have already spoken about needing an EORI number beginning with GB if you are importing goods from the EU. If you're exporting, you'll need this, but you'll also need an additional EORI number from an EU country if your business will be making customs declarations or getting a customs decision in the EU. So this won't apply to all businesses because you won't always be doing the declarations in the receiving country yourself. But if you're going to be doing that, then you do need to have an EU EORI number. And you can get this from the customs authority in the EU country where you submit your first declaration or where you request your first customs decision, if that's something that's been necessary. Whether or not you're making customs declarations in an EU country will depend on the Incoterms that you agree with your customer. That's why they're very, very important. And while it might seem easier to use an arrangement that puts the onus on them as a customer, you may have to consider whether they'll be happy to take on that additional responsibility. You know, for example, if they're importing from another EU country, they won't need to take on that responsibility. So in terms of competitiveness, it's something that you need to keep in mind in terms of, you know, where you want to put the work, whether it's you or your customer. Before we get into the detail on the customs process, it is worth noting that for shipments under £900, it used to be 873, but it's now £900, only a simple customs declaration is required. And for companies that are only doing these sorts of transactions, an EORI number is not required for these. So I've included a link on this slide with more details and information if you want to check on that, if that applies to your business, because it can save you a fair amount of work in terms of getting ready. I've put in a word about tariffs here because, you know, as I mentioned earlier in rules of origin, you do need to make sure that your goods will meet the rules of origin requirements to ensure tariff-free movement to the EU. And if they don't, you'll need to check what tariffs, if any, would be applicable. So the link on this database, on this slide, takes you to an EU database where you would be able to check on this. Hopefully this will not apply because you'll be able to meet the rules of origin requirements, but it's worth knowing what you need to do in case you don't. Unlike with importing from the EU into the UK for exports, there's not going to be any phased introduction. So you do need to be prepared for a full customs process for all products going to the EU from the 1st of January. And as with importing, you will need to decide if you're going to use a customs intermediary. This will greatly simplify things for you, at least in the short term, and in my opinion, it should be given serious consideration. But if you're not using a customs intermediary, there are a number of steps that you need to follow before you're even in a position to start completing your own export declaration. So firstly, you need to register to use the Customs Handling of Import and Export Freight system. And once you've done this, you can then register for the National Export System. So to use these systems, you will need training and specific software. And then an additional step, once you have all of the above in place, is to ensure that the declarant in the destination country, also known as the importer of record, has all the necessary paperwork in place to be able to clear the goods through customs in their own country, unless you're going to be doing that on their behalf. So that, again, that's something that needs to be agreed between you and your customer. So just a word about the Common Transit Convention. So the Common Transit Convention is used for moving goods between the EU member states. So the European Free Trade Area countries, which are Iceland, Norway, Liechtenstein and Switzerland, as well as Turkey, Macedonia and Serbia. The UK is currently a member of the CTC, or the Common Transit Convention, as an EU member state, and it had already negotiated membership in its own right. That was regardless of any deal being agreed with the EU, so that's something that was already in place. And what it means is that traders only make customs declarations and pay import duties, if they were applicable, when the goods arrive at their final destination. So that has obvious cash flow and reduced administration benefits to businesses. Just a look at some special customs procedures. It is worth being aware of certain special customs procedures because these may help you with costs and cash flow when you're trading internationally. And although for most products trade with the EU will be tariff-free, it's worth looking at these options if, for example, your product doesn't meet the rules of origin requirements, or if your business is involved in a more complex supply chain. So where materials come from a range of countries, perhaps some of which don't have free trade agreements with the UK. So first of all, customs warehousing. If you're not planning on accessing or altering your goods, except for essential maintenance work, they can be stored in properties which are supervised by HMRC. These are known as bonded warehouses until they are required. And then under this procedure, you don't need to pay duty or VAT until the goods are removed from the warehouse or entered into another customs procedure, which could be re-exported or brought into circulation. Inward processing. So as the name suggests, inward processing applies to goods which are being imported in order to be processed. Once they're processed, the goods either need to be exported back outside the UK or released into free circulation within the UK. And at that point, any relevant customs duty, import VAT and excise, if applicable, will be payable, but only after they've been processed. And then outward processing is similar to inward processing, and this procedure allows relief from customs duty when exporting goods for processing or repair. So when goods are re-imported, a full or partial duty relief can be claimed. In order to apply for this procedure, the goods must originate in the UK or have been imported into free circulation within the UK, having completed all customs formalities and any charges paid. Moving on to end use relief. So if you're using this procedure, could see you pay reduced customs duty or nothing at all on some goods. This procedure applies to items such as shipwork goods, aircraft and aircraft parts, hydrocarbon oil, marine propulsion engines, military goods, fish and cheese. It can only be used for specific purposes and within a set time period. And while customs duty may be reduced or not required at all, other importation charges such as VAT, excise duty and any anti-dumping duty may still apply. So it's definitely worth considering whether any of these reliefs might apply to your business situation. As I say, for inter-EU trade, most of it will be tariff-free, but in the event that it's not, then some of these are useful things to be aware of. Temporary admission or export is likely to be useful if you're attending an exhibition or taking samples to and from a country, and you can use an ATA carnet, which means that you can avoid paying import and export duty. So this again is a process that's currently used for with the EU for countries where there isn't a trade agreement in place. So it shouldn't be needed for activities within the EU, but you should be aware that customs paperwork will still be needed in some of these situations where you are taking goods out of the country and bringing them back in for exhibition purposes. So I've put a link to the more detailed information on all of these special customs procedures on the slide, which you'll get from the handout if you think that this is relevant to your business. New regulations for food and drink companies. So if you're a food or drink exporter, there are some specific areas that you need to review to ensure that you remain compliant with EU laws post-Brexit. So EU food labelling rules apply to all food and drink placed on the EU market, independently of its place of production. And this includes a requirement to identify a food business operator, or an FBO, who's responsible for ensuring that the product labelling complies with EU food information law. This means that a producer placing a product on the EU market must itself be established in an EU member state, or alternatively, identify an EU importer who will then have responsibility for that information. Currently, a UK business selling prepackaged foods in the EU can put its own name and address on the product, but this will no longer be the case. It should be noted that products shipped to the EU before the end of transition, so within the next couple of days, can still lawfully be sold afterwards, even if they only show the UK address. So from the 1st of January 2021, food and drink exports, products exported from Great Britain to the EU will need to display the name and address of the food business operator responsible for complying with the food information rules. And as I've stated, this must be either an EU or address, or it can actually also be a Northern Irish address at which the business is established, or the importer of the products into the EU or Northern Ireland, because the British address of the producer will no longer be valid. And it would mean that the product could no longer be lawfully sold in the EU. In addition to these labelling requirements, strict new border controls will apply specifically to exported animal and fish products. And these include the need to produce an export health certificate, and for fish, a catch certificate. And food products will have to be shipped via an EU border control post, which must be given notice of their expected arrival. So if you intend to export certain foods of animal origin into the EU, for example, red or white meat, or fish and fish products, or dairy and egg products, you must also ensure that your business is listed as an approved establishment with the EU. EU imports on certain plants and plant products, such as root and tuber vegetables, leafy vegetables, most fruits and some seeds, that includes the need for phytosanitary certificates and potentially EU border checks, that will also apply from the 1st of January 2021. So this is quite a complex area, for more on these issues, you should see the EU's guidance on Brexit and EU food law, and also the UK government guidance on preparing food and drink businesses for the end of transition. And this includes more detailed information on labelling and on exporting animal products and fish products. And the Scottish Government has also published an update for the food and drink sector, which summarises the most relevant import and export issues. Obviously, some of these are still currently being updated following the deal, but most of the kind of key information is already there and doesn't change. Okay. Just a word on VAT. Sorry, I've lost my place slightly. Sales to EU countries should be zero rated as exports, but your importer will need to be aware of the need to pay relevant import VAT in the country of destination. And another point to be aware of is that when the transitional period between the UK and the EU comes to an end, the UK will become a third country for VAT purposes. So if your business is currently VAT registered in an EU country, you will, in most cases, have to transfer any of these registrations to a registration with a fiscal representative, and also set up the relevant financial guarantees. So to be clear, you'll not require a fiscal representative if you're trading via a local entity or a branch in a given country. It's only when you're a non-EU company holding a VAT registration without physical presence in the country. I would say that if your business is registered for VAT in the EU, it is advisable to discuss your position with a suitably qualified accountant to make sure that the arrangements that you put in place are optimal for your own business situation, as this can be quite a complex area. Okay, so moving on to Northern Ireland. How trade would operate for the island of Ireland was one of the biggest hurdles to clear during the Brexit negotiations. The UK's position was that it didn't want to create a border between Northern Ireland and Great Britain, while the EU's position was that it needed to preserve the integrity of its single market. Neither side wanted to implement border controls between Northern Ireland and the Republic of Ireland, so that was common ground. And the result is the Northern Ireland Protocol, which forms part of the withdrawal agreement and takes into account the special circumstances of the region. So with regard to Scottish businesses trading with Northern Ireland, there are a few key points to note. I've also put on this slide a link to the latest agreement, the agreement that was made a couple of weeks ago by Michael Gove and his counterpart, which gives the kind of up-to-date information on how the kind of nuts and bolts of how the Northern Ireland movement will be managed. So that's what the link on this slide takes you to. The key points are that goods shipped from Great Britain to Northern Ireland will be subject to customs declarations. The intention was always that they would be tariff-free, and the agreement for tariff-free trade that was reached with the EU last week makes this a much easier situation to manage. Northern Ireland must also align with certain EU rules in areas such as agri-food and industrial products. And another example of this is the continued validity or continued requirement for the CE mark for goods that are being put into the Northern Ireland mark, rather than the new UK conformity assessment mark, which will apply in the rest of the UK. I'll be saying a little bit more about that later on. But for companies that are trading with Northern Ireland, the government has launched what's known as the Trader Support Service. And this is a free-to-use service which will guide you through the process of moving goods between Great Britain and Northern Ireland, and it can also complete customs declarations on your behalf. So if you are trading with Northern Ireland, either importing, bringing goods in or sending goods to Northern Ireland, it's definitely worth registering with the Trader Support Service as soon as possible. There was a cut-off date to guarantee a registration number in time for the 1st of January, and that was the 23rd of November. If you are trading with Northern Ireland, it's worth applying for that as soon as possible to get the help that's available from the government on that. Okay, so just a quick time check. We shall take just a 5-minute break. So if we come back at 11 o'clock, and then we'll move on to the other areas, starting off with selling services to the EU, and then looking at a range of other areas after that. Okay, so reconvene at 11 o'clock. Okay, so hopefully you've all got a fresh cup of tea or coffee and ready for the second half. My laptop doesn't like being left alone for a few minutes. Here we are. Okay, so just going to talk a little bit about selling services, and there are a few areas that service businesses need to consider. But before I go into these, because this is a question I get a lot, I should point out that services businesses do not need an EORI number. This is purely for businesses that are moving goods. So unless you're a services business that also moves goods, you don't need an EORI number. And also, there are no tariffs on services, so that's one less thing for you to worry about. Although we're tariff-free, but there's no rules of origin, that sort of thing to be worrying about for services. To help with finding out more information, I've also added some links to the handout. The deal agreed last week, it covered services to a small extent, but there are expected to be further talks and potentially a further agreement on services. It's a huge part of the economy, as we all know. But based on what we know at the moment, here are some of the areas that services companies do need to be aware of. So firstly, trade regulations is an important area. So you should check the national regulations of any country that you're doing business in to understand how best to operate and to ascertain whether there's any additional action required, whether you need to get any certifications or other, other legal compliances. Most trade associations are providing quite useful post-Brexit advice to companies in their sectors. So if that is applicable in your sector, it's worth checking with these sources for any sector-specific relevant information and checklists that might be available. Professional qualifications is a big one for a lot of services companies. If you work in a profession that is regulated, so it needs to be a regulated profession for this to be something that you need to consider. So regulated either in the EEA, which is the European Economic Area, or Switzerland. So for example, engineering or accountancy. You will need to have your UK professional qualification officially recognised, which in some cases is pretty onerous. So again, that's something that you need to look at specific to your own situation. It will need to be recognised by the appropriate regulator for your profession in each country where you intend to work. So there's not a pan-EU solution to this either. And you will most likely need to do this even if you're only providing temporary or occasional professional services. So as I've mentioned already, it's really worth checking with any professional bodies and trade associations for specific advice on this relevant to your particular business situation. Then just looking at VAT, so VAT on services is a bit different to VAT on goods, and there isn't a general zero rating on all exports. It's actually quite a complicated area because there are different rules depending on the type of service that you provide and also where or how you provide it. So I've included a link to a page that explains about place of supply rules for services and how this affects what you should do from a VAT perspective. Just a slight health warning on this. The page, which is from the gov.uk website, it hasn't been updated since 2018, but it is the most up-to-date one available. So it refers to the UK as if it were still in the EU. I'm very hopeful that it will be updated soon to reflect the new position. It's still useful to use as a reference, but to all intents and purposes, you should read it as though you were looking at dealing with another non-EU country, so just because of the way that it's written. As I say, hopefully that will be updated soon, but it is always worth checking what when information dates from. An important area that you do need to be aware of, though, is VAT on sales of digital services, and I've included a link to more detailed information on that if this applies to you. So if your sales exceed what is a pretty small threshold of £8,818, you do need to charge VAT in the EU country, and there is a specific system for this called MOS, which stands for the Mini One-Stop Shop. Again, I've included a link in the handout because you will need to register for MOS in an EU country from the 1st of January 2021 to use the service, because all current UK MOS accounts will no longer be valid. And there are other developments coming later in the year on this. So again, that's something to keep an eye on and to find the ways to simplify how you charge VAT in these situations. So these are some of the areas specific to services companies. In the rest of the webinar, I'm going to be talking about a range of topics that potentially apply to all businesses, both services and for those selling physical goods. But as I've said, to help with services companies to find out more information, I've added links to the handout. And these take you to a comprehensive list of all the considerations for services businesses. Some apply to some and some not. And also further detailed information as well as a country guide for each EU member state, because requirements for each country can vary in this area. It's not a pan-EU system. Okay, so moving on to protecting intellectual property. For many businesses, their most valuable asset is their IP. So by IP, I'm talking about brand names and logos protected by trademarks, talking about product designs, patents, and also copyright material. So during the transition period, there's been no change to the status of EU IP rights in the UK. In the main, the IP provisions of the EU withdrawal agreement seek to preserve the essence of these rights, also after the end of the transition period. The UK government has published a guidance for those holding various types of EU IP rights to explain how the UK will deal with these rights from the 1st of January 2021. And I'll talk about the key areas now. So firstly, trademarks. So EU registered trademarks will no longer protect trademarks in the UK. Instead, the Intellectual Property Office in the UK is creating a comparable UK trademark for all rights holders with an existing EU mark. So there will be no cost for trademark holders, and the Intellectual Property Office has said that it won't issue new UK registration certificates. However, the details will be accessible on the UK government's website, so you can go there and check that your trademark is showing if you believe that it should be there. Where an EU trademark application is still pending at the 1st of July 2021, the applicant will have 9 months to apply to register a comparable UK trademark while retaining the filing date of the pending EU trademark. In this case, the usual UK fees will apply, so it will cost. Parties with an EU trademark can opt out of the comparable UK trademark on request after the 1st of January 2020, as long as the comparable UK trademark has not been used in the UK, assigned or licensed, and is not the subject matter of an agreement or the subject of litigation. So then moving on to registered community design. So registered community designs granted by the EU Intellectual Property Office will similarly no longer be valid in the UK, excuse me, but will be immediately and automatically replaced by UK rights. The equivalent UK design right will be recorded on the UK register at no cost to the registered community design holder, and it will retain the registration and application dates of the registered community design and also inherit any priority date. Holders of registered community design applications that are pending on the 1st of January 2021 can apply within 9 months for the equivalent UK right, and they will retain the filing date of the pending registered community design, but as with the pending EU trademarks, the usual UK fees will apply. Again, registered community design holders will be able to opt out of the equivalent UK right after the 1st of January unless the re-registered design has been assigned or licensed, or is the subject matter of an agreement, or if the holder has raised proceedings based on the UK right. In the case of unregistered design rights, these will no longer be valid in the UK at the end of the transition period, but again, they will be immediately and automatically replaced by UK rights. The designs that are protected in the UK as unregistered community designs before the 1st of January 2021 will be protected as a UK continuing unregistered design for the remainder of the 3-year term that is attached to it. And a UK unregistered design right called supplementary unregistered design will be created to ensure that the full range of design protection provided in the UK prior to 1st of January 2021 will remain available. In respect of patents, it will still be possible to apply to the European Patent Office for patent protection that will cover the UK, and existing patents from the European Patent Office will be unaffected. However, one change is that the UK will not participate in the proposed Unified Patent Court because it's withdrawn its ratification of the Unified Patent Court agreement. In terms of copyright, most copyright works will still be protected in both the EU and the UK due to the UK's participation in the international treaties on copyright. For the same reason, EU copyright works will continue to be protected in the UK, whether the works were created before or after the end of the transition. However, UK consumers' ability to access UK online content in EEA member states may be affected, as the EU portability regulation, which allows EEA consumers to access their online content services elsewhere in the European Economic Area, will no longer apply to the UK. Then on database rights that exist in the UK or the European Economic Area before the 1st of January 2021, these will continue to exist there for the rest of their duration. However, UK citizens, residents and businesses will not be eligible to receive and hold database rights in the European Economic Area for databases created on or after the 1st of January 2021. So they'll need to therefore consider whether an alternative means of protection can be relied upon in the European Economic Area, for example, through licensing agreements or copyright. After the 1st of January 2021, there will also be some changes to the UK system for the exhaustion of IP rights in parallel trade. So IP rights in goods placed on the UK market by or with the consent of the rights holder may no longer be exhausted in the European Economic Area. And this means that businesses may need the right holder's consent to export IP protected goods from the UK to the European Economic Area. Similarly, IP rights holders will need to consider whether to allow parallel exports of their IP protected goods from the UK to the European Economic Area. And where goods are placed on the market anywhere in the European Economic Area prior to the 1st of January 2021 by or with the consent of the rights holder, the IP rights will have been exhausted in the European Economic Area and the UK. So one example where this might be applicable is if, for example, you were the UK distributor for an American brand. If you bring the products into the UK and then re-export them into the EU, you may need to get permission from the brand owner to do that under these changes in IP. I've included a link to IP after Brexit on the slide here that takes you to the Intellectual Property Office. It's very useful if it's something that you need to that you need to consider for your business, and it may also be an area where you'd want to consult with a lawyer if it's again if it's something that's important and you need to make sure that you are maintaining the protection that you've enjoyed up until now for your intellectual property. Okay, so now looking at CE marking. So for goods being sold in Great Britain, so that's Scotland, England and Wales, the UKCA or the UK conformity assessed marking is a new UK product marking that will replace the CE mark for most goods. In the case of Northern Ireland, the UKCA marking alone cannot be used, so instead you'll need to continue to use CE marking or potentially a new UK NI mark that's being introduced. So this is something you need to consider if you are selling goods to Northern Ireland. The technical requirements that need to be met, as well as the conformity assessment processes and standards that can be used to demonstrate conformity, will largely be the same as now. So this is good news. So if you're ready, you can use the UKCA marking from the 1st of January 2021. But in order to allow businesses more time to adjust to the new requirements, you will still be able to use the CE marking for a further year, so still be valid until the 1st of January 2022. This is the case for most products, but there may be some exceptions. So, for example, if rules diverge between the UK and the EU within that period, then you won't be able to continue using the CE mark. So that's something that you need to keep an eye on. In terms of complying with EU regulations, if you are a UK manufacturer of goods selling to the EU, you should be reviewing whether your existing conformity assessments and certifications will continue to be recognised in the EU. So UK bodies that are currently approved by the EU for certification purposes will no longer be recognised by the EU unless the deal provides for that. I've not been able to find that within I have read through some of the text. I've not been able to find that, but that's something to be aware of. So if the deal doesn't provide for that, then the results of conformity assessments carried out by UK-based bodies will no longer be recognised. So this means that UK assessed products will no longer be able to be placed on the EU market unless they've been reassessed and remarked by a body that remains EU recognised, or the manufacturer's files are transferred to an EU recognised body before the end of transition. The good news here, though, is that CE marking based on self-declaration of conformity will still be possible, and in practice it can be applied to most products. So for more information on this, I've put a link there to placing manufactured goods on the EU market, which gives you some more detail and some more resources and information if you need to go further into this area. And then just a word on EU-based distributors. So if you have an EU-based distributor, they, as we've said already kind of earlier on, they'll become an importer from the 1st of January 2021. So in terms of compliance, they will need to make sure that goods are labelled with their address and either your details or your EU, EEA or Northern Ireland-based authorised representatives' details, which may also be the importer. They also need to make sure that the correct conformity assessment procedures have been carried out and that goods have the correct conformity markings. Also, that you as the manufacturer have drawn up the correct technical documentation and complied with the labelling requirements, and that they maintain a copy of the Declaration of Conformity for a period of 10 years, and a very basic one, that goods conform with the relevant essential requirements. And if you use an EU-based fulfilment service provider, they will need to request certain compliance information from you, and goods will need to be labelled with their details, unless they ask that you appoint an authorised representative who can fulfil these obligations instead. So that's a conversation that you need to, if you use an EU-based fulfilment company, that you will need to have with them in terms of, will they take that responsibility, or do you need to appoint somebody else to take on that responsibility? The good news is that the introduction of this rule doesn't come in until the 16th of July 2021, so there is a little bit more time to prepare for this. Okay, so now moving on to the e-commerce directive. So the e-commerce directive currently allows European Economic Area online service providers to operate in any EEA country while only following relevant rules in the country in which they are established. So for a UK business, you can operate in any EEA country as long as you are complying with the UK rules. After the transition period, this framework doesn't apply to UK providers because the UK will have left the European Economic Area. When you're looking at this, first of all, you need to consider whether your services are currently in scope of the directive. And if so, you need to ensure that you're compliant with relevant requirements in each European Economic Area country that you operate in. So in terms of assessing whether you're in scope, the e-commerce directive applies to what are known as information society services. So these are defined as any service that is normally provided for payment. So that includes indirect payments such as advertising revenue, at a distance or remotely, by electronic means, and at the individual request of the recipient of the service. So in practice, this covers the vast majority of online service providers, including online retailers, video sharing sites, search tools, social media platforms, and internet service providers. Depending on the nature of your online services, you may already comply with these requirements, so that could mean that there's little or no immediate change or action that you need to take in order to be compliant going forward. For most, if not all companies on this webinar, it's likely that your service is based in the UK. The directive refers to this as your place of establishment, which basically means where you do business on a long-term basis. So once you've established, if you are within scope, based on the criteria that I've mentioned, and that your place of service is the UK, you do need to check for any legal requirements in any European Economic Area countries that you operate in. And you also need to consider how you will ensure ongoing compliance in the event that an individual European Economic Area country changes its requirements governing online activities. Again, it's probably worth considering seeking legal or other professional advice, perhaps trade body advice, if you're unsure about how to go about ensuring that your business is and will continue to be compliant. And again, I've put a link on the slide here to a guide to the e-commerce directive post-Brexit, which gives you some useful resources and guidance. Data flow. So there are a number of reasons why companies might need to transfer personal data between the UK and the EU. So for example, an organisation in the EU may use a service provider in the UK, or a group of companies may share information such as employee information between a subsidiary and a parent company. Equally, if you're on an online business with direct customers in EU countries, you may fall into this category. So the GDPR, or General Data Protection Regulation, that all UK companies should now be compliant with, came about as a result of an EU directive. So that's an EU law. It will be incorporated into UK domestic law once the transition period ends, and it will also include the rules on transferring data from the UK to the EU, which in the short term at least will continue to be permitted as a matter of UK law. However, transferring data from the EU to the UK may not be so easy. So the EU has an adequacy assessment mechanism which authorises the transfer of personal data from the EU to approved non-EU countries. This authorisation is conferred by the European Commission, which at this point has still not made an adequacy decision regarding the UK. So the deal agreed on the 24th of December does, however, provide a 6-month grace period for the continuation of data flow from the EU to the UK, and it's hoped that adequacy will be granted sometime in 2021. So just to explain this a little bit further, as a non-EU country, the UK is now subject to the standard adequacy assessment process. And this actually began following the UK's departure from the EU on the 31st of January 2020. In theory, the approval should be straightforward since the UK data protection regime will still be consistent with EU law. However, it's not automatic and it is taking some time. In particular, the adequacy assessment covers things like the UK's laws on data retention and also access to data by intelligence agencies, which have previously been found to be incompatible with EU law. So if data flow is an important process in your business, you do need to keep a close eye on this. In the event that adequacy is not granted in the next 6 months, there are measures that businesses can take, and this may include agreeing what are known as standard contractual clauses, or SCCs, with the party who would be sending you the data. So standard contractual clauses are clauses that the Commission has approved for use when transferring personal data to countries that do not have an overarching adequacy approval. And there are different standard contractual clauses depending on whether the relationship is one of controller and processor or controller to controller. And if you're involved in data, then you'll understand what these different terms mean. So the UK government has published guidance on data protection during and after the transition period. And the Information Commissioner's Office, or ICO, has also issued guidance on data protection. And it also provides some really useful interactive tools to help you assess your own situation as well as it also provides downloadable templates for different scenarios, for example, for standard contractual clauses. There will also be obligations on UK organisations that offer goods or services to data subjects. So that is a person about whom a controller holds personal data, which could identify them either directly or indirectly in the EU, or who otherwise monitor their behaviour. So if your business does this, and this may include you if you're an e-commerce seller with, selling to customers in EU countries, you will need to appoint a representative in the EU and also understand how and by which regulator your activity in the EU will be supervised. So there are exemptions from the requirement to appoint a representative, and these apply to public authorities, and more likely to be on this webinar, companies whose processing is only occasional, of low risk to the data protection rights of individuals, and does not involve the large-scale use of special category or criminal offence data. So again, as I say, on the ICO website, with where there's a link to that on the slide that you'll get with the webinar handout, there is an interactive tool which helps you to go through and actually assess whether you are within scope of this or not, which is really, really helpful. And there will be a similar requirement for controllers that are located elsewhere in the UK that offer goods and services to data subjects in the UK to appoint a representative in the UK. So it is a two-way arrangement. Again, a changing area, and one that you should keep an eye on if it is important to your business. And again, also one where perhaps legal input would be useful. Speaking of legal input, just looking at contracts and key things that you need to check. So it's really vital that you review any existing contracts to identify any potential risks, liabilities, or complications that could arise from the end of the transition. You should also consider how new contracts should be drafted to ensure that they're fit for purpose in the post-Brexit era. For many of the items I'll go through, it is highly advisable to consult a suitably qualified lawyer for detailed and specific advice. But if you're not sure that this is going to be necessary, you can carry out your own pre-check to determine whether your contracts need to be formally reviewed and whether a lawyer actually needs to be involved. So some of the things that you need to be looking out for your contract are particularly any references to the EU. So this could be any references to EU law, to EU institutions, or crucially, to the UK being an EU member state. So an example of a potentially problematic reference would be a description of the geographic reach of a content. So such as a territory in a license agreement or a distribution agreement that refers to the EU, but is intended to include the UK. So if your contracts do contain such terms, you should review them and take a decision on how to address this by rewriting and then agreeing any changes that you think are necessary with your trading partner. For transactions involving the movement of goods, the correct use of Incoterms, which I spoke about earlier, will help significantly with providing clarity on buyers' and sellers' respective responsibilities. Excuse me, and there are some key issues to be aware of when you're drafting and renegotiating existing contracts. So for example, for any additional operating costs on goods that are being traded between the UK and the EU, who is responsible for these costs? So the cost of doing customs declarations, for example, these sorts of things. If border delays result in late delivery or performance, is that the seller's responsibility or problem, or is it the buyer's? Or is it a shared responsibility? If a contract includes services, where does the risk of any restriction on freedom to provide services between the UK and the EU sit? So as I said, the services area is not fully clear yet, so that may still be something that you need to look at. If a restriction on the freedom of movement for workers causes a labour shortage for the seller, but also possibly for the buyer, does that give relief from contractual performance? If cost or time issues arise from additional licensing, certification, labelling, packaging, and any other regulatory requirements, How do you allocate these risks, and are they shared? And if so, how are they shared? It's worth being aware that UK and EU regulatory requirements might diverge in the future. So think about who's responsible for monitoring this and for complying with any changes to regulatory requirements. Looking at currency, so currency fluctuation is a feature of international trade regardless of Brexit, but you know, following the 2016 referendum result, when the value of the pound fell considerably, we need to be mindful that a range of circumstances, including political announcements, can precipitate shifts in currency exchange rates. So in general terms, if the pound weakens, this is good for exporters as overseas buyers can get more for their money, and bad for importers because the opposite applies. And the reason I'm mentioning it under this contractual section is that when it comes to contracts, you should consider what currency you're quoting in, be careful of committing a price for too long a period, and ideally include caveats relating to currency fluctuations, which in a good agreement would protect both the buyer and the seller, because it is a partnership, or it should be. Most contracts will stipulate the law by which they will be governed and the place that any dispute will be heard. So you should check if that still works following the end of the transition period, or whether this needs to be something that's renegotiated with the other party. And most contracts will have a force majeure clause. So it's an interesting question to consider whether a Brexit-related impact on a party's ability to perform would give rise to a right of relief. And this will depend on how the clause has been drafted. So you need to then consider what impact that would have on the contract and what obligations, if any, the contract imposes on the affected party to mitigate the impact. So yeah, it's a minefield of potential impacts to navigate. And as I said at the beginning of this section, seeking professional advice is highly advisable if you are unsure at all of how your contracts might stand up going forward. Okay, so moving on to HR issues and specifically initially talking about employing EU nationals. So if you employ any EU nationals, you should urgently make sure that they understand what steps they need to take to continue living in the UK post-Brexit. So it was confirmed a while ago that EU citizens living in the UK prior to the end of the Brexit transition period would be able to stay in the UK regardless of any trade deal. So that's been known for a while. So any EU, European Economic Area, and also Swiss citizens and their family members residing in the UK before the end of the transition period who want to stay in the UK longer term must apply for settled status under the EU settlement scheme, or for pre-settled status if they don't yet have the necessary 5 years of residence in the UK. The deadline for applications is the 30th of June 2021, but only those resident in the UK before the end of the transition period are eligible to apply. So settled or pre-settled status will provide a right to live and work in the UK for a period of time, and settled status is a type of indefinite leave to remain. So although UK resident EU citizens and their family members will generally be entitled to settled or pre-settled status, it will not be granted automatically. And as an employer, you therefore need to encourage any eligible employees to apply under the scheme well in advance of the closing date of 30th of June 2021. If they don't apply in time, it's likely to have serious implications in terms of their immigration status and their ability to work in the UK. There's no fee for making an application to the scheme. And for more information on the EU settlement scheme, you should look at the UK government's toolkit, which I have provided a link to. So this is aimed at giving employers information on how to support EU employees that are applying to the settlement scheme. You should be aware that as an employer, you can direct employees to relevant information, but you should not provide immigration advice because this is strictly regulated. So for looking forwards, for EU, European Economic Area and Swiss nationals who want to move to the UK after 11 PM UK time on the 31st of December 2020, these will have to apply for an immigration status in accordance with the UK immigration system in place at the time. Details have been published on the new points-based UK immigration system, which will come into force on the 1st of January 2021. And this will introduce a new single skills-based, points-based immigration system that will apply to EU and non-EU citizens alike. Applications under the new rules are already open, so if this is relevant, you should be familiarising yourself with the new rules now. You may wish to consider applying for a sponsor licence if you don't already have one, as this will be required to sponsor employees under the new rules. And just a caveat there, there may also be delays in processing applications due to COVID-19. It's worth also noting that Scottish Enterprise has a specialist department, which is called Talent Scotland, who are able to assist with immigration-related queries relating to bringing people into the UK to work. And as well as running regular webinars, it can sometimes be possible to get one-to-one consultations to receive initial advice and guidance. So a useful service to be aware of. And then the final topic is post-transition period travel to the EU. So the key changes on travel post-transition relate to passport validity, length of stay, and healthcare considerations. So if you're planning to visit the EU after the 31st of December 2020, you'll need to comply with the new travel requirements on passport validity. Travel to Ireland won't change because Ireland and the UK form a separate common travel area that does remain in place. But if you're travelling into the Schengen area, which includes all EU countries except Bulgaria, Croatia, Cyprus, Ireland and Romania, and then also includes Iceland, Liechtenstein, Norway and Switzerland. If you're travelling into this area, your passport must have been issued no more than 10 years prior to the date of arrival in the Schengen country, and it must be valid for at least 3 months after the intended date of departure from the Schengen area. As a third country national, you would be able to stay in the Schengen area for up to 90 days, so you may need to have up to 6 months validity on your passport from the date of your arrival. And if you're travelling to Bulgaria, Croatia, Cyprus or Romania, you'll need to check the national entry requirements for these countries because they'll be slightly different. When you're travelling to the EU after the transition is ended, you'll need to ensure that you get appropriate travel insurance with healthcare cover. Your European Health Insurance Card or EHIC card, as announced in the deal, will be valid until its expiry date, but obviously not renewable. And there is talk of a new UK government scheme for travel healthcare, but the details of that are not available yet. There's more information on post-Brexit travel considerations on the link that I've provided on the slide here, which is available on the webinar. So I would suggest that you consult that if you are planning to make a trip to the EU next year. Okay, so I've chosen to end on one of the slightly more straightforward topics, give the grey matter a little bit of a break. Some of this is really quite technical, but hopefully the resources that I've been providing you with, or that you will get after the webinar, will help you to go through the detail in any of the areas that are particularly relevant to your business. Hopefully you still have the will to live and also to continue doing business in the EU beyond Brexit, despite all the complications and additional requirements that I've outlined. It probably does all feel very daunting, but there are lots of resources to help. And the main thing is, if you haven't already started, is to get started on the key items for your business. In some areas, it will be best to seek professional support and bear in mind that although this will cost you money in the short term, it will most likely be worth it in the longer term if it prevents or mitigates any issues. I've answered a few questions as we've gone along. I had an opportunity during the break to do that. If you do, I think I've got one question outstanding, which I'll have a look at in a moment. If you do have any other questions that you want to put to me, feel free to put those into the Q&A section in the middle of the control panel. What I will do is either answer them directly in the webinar handout that will come to you later today, or if they need more investigation, then there may be a slight delay, and we can send that out separately. But feel free to put any questions that you do have. But thank you very much for your time, and good luck with your future trade with the EU. So thanks very much again, and goodbye.